My name is Terence Carter, and I'm the managing partner of Carter's. I'd like to warmly welcome everyone to the second of Carter's 2000 Winter and Spring Charity and Not-for-Profit Law webinars. Details of our webinar series can be found at our website of carters.ca. The webinar topic today is Contract Essentials for Charities and NFPs, and is being presented by Esther Shainblum and Barry Kwasniewski, both partners at our Ottawa office. Esther practices in the area of charity and not-for-profit law, as well as privacy and data management. Barry practices in the area of employment law, as well as risk management and insurance. Both Esther and Barry are involved in writing and reviewing contracts on a regular basis for their clients. I know that you're going to really enjoy Esther and Barry's presentation today, as they have a lot of experience in this area of the law. There's obviously a significant interest in this topic, as we have more than 520 people registered for the webinar today. As is the tradition of our law firm, Carter's recognizes that its work and the work of its community partners takes place on traditional Indigenous territories throughout Canada. We acknowledge the 46 treaties and other land agreements that covers the province of Ontario. We are thankful to work and live in these territories and acknowledge the enduring stewardship of First Nations, Métis, and Inuit people who have cared for these territories since time immemorial, and who continue to contribute to the strength of Ontario and to all communities across Canada. A link to the presentation handout materials for today's session was sent to you in the 1-hour reminder email you should have received, and the video replay will also be available on our YouTube channel within 24 hours after the webinar. The webinar today will consist of a presentation by Esther and Barry for about 40 to 45 minutes, followed by about 15 minutes of questions and answers. If you'd like to submit a question at any time, please go to the Q&A icon at the bottom of your Zoom screen and enter it there. We will attempt to answer as many of your questions as possible before the end of the webinar at 1 p.m. sharp. Please note that the presentation today does not constitute legal advice, and attendees are therefore encouraged to speak to their own lawyers to obtain advice as necessary. Just before we get started, I would not want to lose an opportunity to share a joke or two. These are fresh off the cookie tray. They've been vetted and approved by our team here, and here we go. How do trees get on the internet? They log in. And then my favorite, when does a joke become a dad's joke? When it's fully grown.
Yeah.
Okay, with that, we're going to turn it over to Esther and Barry to start your presentation, and look forward very much to what you have to share. And then at the end, we'll go into a Q&A session together. Esther and Barry, over to you.
Thank you, Terry, and for that rousing comedic achievement. That was great. Welcome, everyone. Barry and I are going to talk about some of the key issues that have arisen in the course of our practices over the last number of years when dealing with contracts in the charity and not-for-profit sector. Because of the risk that a poorly drafted or unfair contract can place on a charity or not-for-profit, this is a really important issue that boards and management of charities need to be aware of. This presentation is not going to be a comprehensive analysis of every single issue that can come up, but it will address many of the key elements that we have come across over the last many years when dealing with contracts in the for charities and not-for-profits. I'm just going to refer to them as charities going forward to make it simpler for everyone in this presentation. So we'll just set the context, talk about some preliminary considerations, key contract elements, and then at the end we'll have some key takeaways. We're going to try to go back and forth a bit and keep this as interactive as possible, but there are limitations due to the technology, so we will do our best. So just to be, clear, we're not suggesting that charities are commercial entities, but what they are doing is living in a world where they are required to engage in a variety of commercial activities in the course of their operations. It's just reality. So you're engaging in contracts with IT people, with bookkeepers, web designers, fundraisers, other consultants, other charities, acquiring goods and services and providing them to others, as well as engaging in contract negotiations, likely with funders. Because of the significance that some of these contracts have to the organization, they can be mission critical, whether we're talking about the dollar value, so that it could place the organization at risk financially, or the nature of the services in question, whether they are so key to your operations that they can place you at risk if the contract is not good, or something that you're providing that might place your organization at risk if your contract turns out to be unbalanced or unfair or poorly drafted. In my experience, a lot of charities rely on sort of the handshake, we're all in this together. This is a charity. We're not going to engage in sort of hardline negotiations. And they are also reluctant to push back sometimes because they are feeling at risk or they really need this agreement. And they will just go in and sign whatever is provided to them. But in fact, this is not a great approach from neither an operational or a governance standpoint. For one thing, charities need to make sure that the contracts they enter into are balanced, that they're fair, that they're clear, and that they're in writing, and that they're being negotiated as fully as possible. We recognize that in a lot of cases, there may not be a lot of scope for negotiation, but there always is a little bit of space. And sometimes it's really important to push back as hard as you can on areas that are of high risk or high significance to your organization. From a governance standpoint, directors of charities have fiduciary duties to act in the best interest of the corporation. This includes protecting them from inappropriate risk. So if a contract is completely out of line, unbalanced, or makes no sense, it's up to the board to say, no, we're not going to take this on because it's not in the best interest of the corporation. There are also fiduciary duties that directors, particularly charitable directors, have to protect and safeguard the assets of the charity. So if you're essentially signing away all your assets or placing them at risk, this is not necessarily in keeping with the director's fiduciary duties, and therefore could be not only a breach of fiduciary duty as well as an operational mistake. And how does the director or management know if they're taking a risk that's unreasonable or if they're risking their assets of the charity in an inappropriate way? And that means it requires engaging legal counsel. Legal counsel can help identify and address and manage and mitigate risks arising out of contracts that you won't be able to identify yourself. And for this reason, it's important to have legal counsel involved in the process as early as possible before things have gone so far that they can't be turned back, or before, and definitely before anything has been signed.
Thank you, Esther. Now, as Esther noted, the importance of contracts for protection of the charity can't really be overstated. And it's important to know that contracts can be oral and they can be in writing. But as a matter of good governance, all your charity's contracts should be in writing. You may think that, well, that's an obvious point. Why are you stating that? But think about some of your most common types of contracts that your charity uses. One of those would be, for example, your employment contracts. We've seen many instances where employment contracts are either almost entirely verbal or are very sparse in terms of what is written. For example, there are no termination clauses in the employment contracts. There are no term set out in the contracts. There's nothing with respect to the protection of intellectual property. So that's an example of where you want to look at your contracts and make sure that they are in writing and that the written contract has the required terms for the protection of the charity and for certainty. What are the obligations of the parties? So a written contract that's properly drafted will protect both parties to the contract, the charity and whatever individual or organization the charity is contracting with. Next slide. Further, if your charity is ever subjected to an audit by the CRA, they're going to have to look at your contracts. They may request written versions of your contracts, and if you don't have them, it could be problematic from the auditor's perspective. Similarly, if your own auditor is reviewing your financial records and requires certain payments or receipts to be documented, having the written contract at hand will assist in the internal audit process. Finally, on that point, the certain types of contracts are required in law to be in writing, such as those relating to the transfer of property and leases. So if your charity is involved in any, for example, lease arrangement, make sure that the lease is a properly drafted lease and will withstand any legal scrutiny. So all this is a matter of good governance for the charity, and the board of directors needs to be aware of these issues. Now, Esther, can you go back and discuss some of the most basic elements of a contract in the next
Sure.
couple slides?
Sorry for all the back and forth. I just wanted to say that we used to have an old joke that a verbal contract is only as good as the paper it's written on. So I always think that's fun. So in law, in order for a contract to be valid, there have to be certain key elements. So one is there has to be a meeting of the minds, that show that both parties understand and agree to what they're agreeing to, that you're not doing something else than the other party thinks you're agreeing to performing another type of transaction. So clarity of terms, demonstrating that their parties are ad idem or that they are in agreement. Consideration means that something of value must be exchanged, whether it's a payment and funds, or I'm providing you with a particular service. There needs to be that consideration, that exchange of value. There must be the written agreement itself is evidence of the agreement or the intention to enter into the contract. And as Barry just mentioned, the need for a written contract is obviously very important, and the signature of each party on the agreement is the confirmation that each party agrees to enter into the transaction or whatever the agreement is relating to. The parties must be legally competent. So if you have an agreement with an individual person, that person has to be of age and must be of sound mind. You can't enter into an agreement that's enforceable with a minor or with a person who is incapable of contracting. When you're dealing with corporations, which is more likely to be the case for most organizations, other than employment contracts and things where there's a personal, such as an individual consultant. But in general, a lot of the providers that you're dealing with or the other entities you're dealing with are in fact entities and are therefore corporations mostly. In those cases, the parties must be correctly identified, which means, if need be, doing a corporate search to make sure that you've got the right name of the other party. You can get into trouble if you've kind of made up what you think is the right name and it's not. There could be an argument there that you haven't got a contract that binds that party. So it's important to ensure you identify the correct party. And if you're dealing with a corporation that has multiple subsidiaries or affiliates or other kind of related entities, you need to ensure you're dealing with the actual entity in question. There are some other key contracts considerations that we wanted to bring to your attention when you're dealing in negotiating, entering into contracts. Again, as I said, this is not every single thing that may come up, but we have identified what in our view are some of the key issues that commonly arise and that people need to be aware of. So one is key definitions, and you've probably all seen it when something is capitalized. So like agreement or parties or services. Sometimes you just see those randomly popping up, these capitalized terms, and that's not the way it should work. Ideally, what we are doing in an agreement is defining key terms for clarity. So we'll say the services are the services outlined on Schedule A, and then it says all the things you're going to do. And we define that as the services, capital S, and you use that term throughout the agreement consistently. If you just say the services, capital S, and you've never defined them, that is of no value. Or if you define it and then you never use the defined term, again, it's inconsistent. What we need to see is defined terms that are used clearly and consistently. And it also keeps the verbiage down. Don't have to keep saying the aforementioned, property or whatever it is. You can just say the property, and you keep that streamlines and keeps the agreements easier to understand. So again, defined terms means you define them, you capitalize them, and you use them consistently throughout the agreement. Who are the parties? I kind of alluded to this before. If you're dealing with an individual, they need to be of age and of sound mind, and you need to know who they are. Is this the right person? So-and-so, the bookkeeper who, practices in Ontario or whatever it is. If it's a corporation, again, I've mentioned the name of the corporation must be correct. If you're dealing with an unincorporated association, this is tricky and best avoided if possible, because the unincorporated association isn't a real entity. It doesn't exist in law. When you're dealing with a corporation, that entity is a legal person and can agree to do things. So it can enter into a contract that's binding on it, which is why it's important to use the correct legal name or business name that's registered. But if you're dealing with an unincorporated association, there's no such legal existence. And therefore, it's tricky to know who the signatory should be. When you're dealing with a corporation, the board of directors, and this is going back to what I mentioned earlier about governance obligations, the board should authorize the corporation to enter into the agreement. This can be done in one of two ways: either specific resolution around that specific contract. So the board approves the agreement with John Doe, the IT provider, or they give a general delegation of authority policy that's passed by the board and says something like, the CEO or executive director is authorized to enter into contracts for a value of up to whatever. And so that authorizes management to enter into the contract without going back to the board. But that doesn't mean the board has not approved it. It means the board has given them blanket approval for certain types of contracts within parameters such as financial limits and or the type of contracts they're allowed to enter into. That doesn't mean that the board has relinquished all accountability. It has not. And anything that doesn't go within that management delegation of authority needs to go to the board. So it's simpler for the board in some ways to do that and easier for management. But again, it does not exculpate the board from obligation to oversee anything. And when you have a contract, when you'll often see things called representations and warranties in the agreement, one of the things you always see is that this agreement has been properly authorized by the party, and so that it is a binding agreement of the entity. The confirmation that the individual signing on behalf of the confirmation is usually on the signature page. It says, I have authority to bind the corporation. If the person is like the cleaning lady and she just came out of nowhere and signed it, the obligation is still, the corporation will still be, likely will be bound, because there's a rule in law that says you don't have an obligation to check that the person signing has the authority. And so the corporation is bound anyway, which means it's important to ensure that people executing contracts on behalf of your own entity have authority to do so. Otherwise, they could bind the entity without having the actual right to do so. If the party is an unincorporated association, there's no entity to sign. It hasn't got the legal capacity to enter into or be bound to a contract. So some human being has to sign it. That could give them exposure to personal liability. And so that's something that, as I said, is a good thing to avoid if possible. So the individual signing may need to have authority to contract on behalf of the unincorporated association and show you that. But it could place both parties at risk if you're going to sue this individual and he doesn't have the financial wherewithal to compensate you for the contract breach that occurred. It's probably not a great idea. Or they can sign as a trustee for the unincorporated association. But again, best to deal with incorporated entities rather than unincorporated ones. Sorry, just looking at my notes. Sorry. So it's important to show in the agreement that there is a meeting of minds, that the parties know what they're talking about, that they're both agreeing to the same thing, and that they are on the same page. You can have an agreement where I think I'm providing you with nursing services and what the other party thinks I'm providing you with kitchen services or something. So that would be a very problematic situation. So the contract should clearly set out exactly what the parties are agreeing to. The transaction or the transfer or the services, the scope of work, any deliverables that are being provided, the deadlines, the schedules, how much money, how that will be invoiced, etc. And all of that can be set out either in the body of the agreement or in a schedule or a separate statement of work that's attached at the back of the contract. That often makes it easier because it doesn't make the contract itself extremely long, but it doesn't really make a difference. Either way, it's part of the agreement and binding. Now, when it comes to things like business terms, the lawyers will generally not advise you. We're not, we don't have the skills, we don't have the knowledge, we don't know your business. So that is not something a lawyer will be able to tell you. Is this a good agreement from a financial standpoint? Or can you agree to, can you send these many flowers to the hospital? We don't know that. So that will be up to the corporation itself to make the business decisions around the agreement. Over to you, Barry.
Thank you, Esther. Just revisiting one point about identifying the entity you're contracting with. That is especially important when you're contracting with an entity that is outside of the country. So if your organization is contracting with a U.S. corporation or a European corporation or even a corporation in Africa, for instance, you got to take extra diligence to make sure that the contracting party you're supposedly contracting with actually is a legal entity. Now, one of the important contracts considerations is how long is the contract going to be? When will it begin? When will it end? Is it open-ended? Is it fixed term? Can it be renewed? And if so, on what basis? So these are things you need to think about carefully when you're entering into a contract or reviewing a contract that is being presented to the charity. Now, one point I'd like to emphasize are automatic renewal clauses. This is a term in a contract that says, let's say you entered into a 2-year contract and the 2-year term will renew automatically for another 2 years unless you provide a certain amount of notice prior to the end of the term. Now, those are risky to enter into, because if you're going to enter into a contract with an automatic renewal, you have to beware whoever is administering the contracts in your organization is up to date with that renewal period and knows when to cancel a contract. Otherwise, you might be stuck with a contract for a term that you don't want to be in, and there's no way of getting out of it because of the automatic renewal clause. So be careful of those types of clauses in your contracts. Now, next slide, please. Going on to the issue of termination, litigation often happens when one party or another party terminates a contract before the end of its term. One of the leading recent cases in Ontario is the Monterosso and Freightliner case. That was a case where Metro Freightliner hired a contractor for a 6-year term, a very long term. And what happened was Metro wasn't happy with the contractor. And after about 6 months, they decided to terminate the contractor without cause. Contractor wasn't happy. He sued Metro Freightliner, and he won both at trial and on appeal, and was awarded over $500,000 in damages for breach of contract. Uh, what happened was the court ruled that there was no termination clause in that contract, so Metro was bound to retain the services of the contractor for the full 6-year term. And after terminating him after only 7 months, after the 6-year term, the Metro was liable to pay him for the entire unexpired portion of the term. So that is a pretty vivid example of what can happen if you enter into a contract, especially a long-term contract, and end it early with no termination clause. So you have to consider, how will the contract be terminated? What sort of notice may be required? If there's a default, will the party that is alleged to have committed the default have the opportunity to remedy default within a certain number of days? In the contracts that we draft, the standard number of days can vary, usually between 10 and 15 days to remedy default. And also, can the contract be terminated early at all? Say you have a 1-year contract. Do you want to have the right to terminate early? Or do you want to make sure that the other party you're contracting with is bound to fulfill their obligations to the very end of the term? So these are important issues to consider, because you don't want to end up like the defendant in Metro Freightliner and be on the hook for a large amount of money because you terminated a contract without the contractual right to do so. Next slide. So also on the issue of termination, these are also on the slide issues that you want to consider in the termination clause of your contract. On the issue of disputes over termination rights, I mean, how are those disputes going to be resolved? Are you going to have a clause that will allow for mediation of disputes or arbitration, or will the parties be allowed to immediately go to court to try to resolve their disputes? Often we have clauses in our contracts that we see or draft that have a mediation clause in them, and if the mediation cannot solve the dispute, the parties have the right to go to a binding arbitration. Binding arbitrations can be good because they're often quicker and less complicated than a court case. And a court case these days can last for years, and you might get an arbitration in a matter of months. I mean, you have to pay for an arbitration and the arbitrator, but the cost saved over going into protracted and expensive litigation will oftentimes be beneficial, and to lean towards an arbitration clause instead of a court litigation clause. So in the end, having a solidly drafted termination clause that you have thought about carefully beforehand can reduce the risks of this type of litigation that unfortunately can and does often happen when one party terminates a contract against the will of the other party. Now, going back to other obligations, Esther, do you have any more thoughts?
Sure. As I mentioned earlier, it's part of the need for clarity. It means having setting out all of the obligations of the parties. Typically, the party that's providing the services should be clearly obliged to do certain things, such as meeting a certain standard in its provision of the services or the goods that it's providing. compliance with laws, regulations, and policies, like potentially even your own internal policies. So if they're going to provide you with temporary staff, for example, they have to comply with your HR policies, for example, or whatever that might be. So a covenant to comply with those requirements, and then potentially screening and being overseeing and being liable for the people that it provides to you, whether they're employees or volunteers. And there's numbers of other types of covenants. So I'll speak later in a few minutes about privacy. So complying with privacy law, for example, or certain types of other obligations might need to be outlined in the agreement.
Thank you, Esther. Now, in certain types of contracts, your charity needs to carefully think about intellectual property rights. For example, if you enter into a contract with for the creation of certain types of content, such as, for example, education manuals, videos, even books that the charity wants to publish. Intellectual property rights and protection of those rights are key and you have to have clearly drafted clauses as to who's going to own the intellectual property created, who will have the right to use it, who will have the right to use the charity's trademarks in promoting the products. So these issues give rise to the issue of drafting up an appropriate licensing agreement in relation to intellectual property, and also having clear clauses in your contract as to which party has the right to use, publish, and to disseminate any type of intellectual property created. There have been, unfortunately, a number of cases where the contracts are not clear in regards to intellectual property, and one party alleges a breach of copyright, and you get into a nasty legal dispute over intellectual property rights and who has the right to use the works created. So you need to avoid that sort of negative situation that could impair the ability of the charity to use the works that have been created. Now, Esther,
And another
on
point
to
that I wanted to
confidential information.
Sorry, I just want to say that we mentioned earlier the duty of the board to safeguard the assets of a charity, and IP, intellectual property, is one of the key assets of all charities and needs to be carefully protected. So that includes the new IP that's being created or developed under an agreement, as well as its previous existing IP that you don't want the other party to accidentally have rights to. So really important area. Another big one that comes up almost in every agreement is the issue of confidential information, which we use this term to refer to an entity's part of business information. It's financial, operational, legal, employee information. Often you'll see contracts with boilerplate, one-sided confidentiality agreement, even clause rather, even if, especially if a service provider just presents you with their standard format. It's always often anyway one-sided, where the party providing the services seems to have all kinds of rights to the other party's confidential information, which can include intellectual property, and there's very little protection. So this is important to ensure, depending on what kind of an agreement it is. This may not be relevant, but it might be extremely relevant. So this is something that needs to be addressed carefully to make sure it's either mutual, if that's appropriate, or if it's one-sided, that at least the other party's obligations are clearly set out, that they don't have the right to use the information for anything other than to provide the agreed upon services, that the party is responsible if one of its people breach the confidentiality agreement, that there's clarity around what the consequences are, and clarity about what happens to the confidential information during the term or after the termination of the agreement, and how long does that obligation persist? Is it forever, 5 years, or some other length of time. Another key thing that comes up is personal information. Again, may not be relevant if you're, I don't know, doing building a building or something, but in most cases, there is personal information that is in some way engaged. And so every contract that has any touching of personal information needs to have robust contractual clauses dealing with who does what, whose obligations are, who has the obligation to protect the personal information, ideally both parties. But if you're transferring personal information to a third party for them to process, which has a particular meaning of basically doing stuff to it, like accessing it, copying it, disposing of it, sharing it, whatever it might be that's processing. If the other party is processing it, they should have very clear obligations to comply with privacy law and to compensate you for any failure to do so, because an outsourcing entity such as the charity is going to be liable if the third party breaches the privacy. So you need to ensure that these clauses are robust, and particularly when you're dealing with entities that are doing, as I've said here, cloud service or outsourcing of payroll or IT stuff. If you're dealing with health or personal information, personal financial information, these are seen as highly sensitive, and therefore even more carefully drafting needs to be engaged here to make sure that there are appropriate provisions to safeguard the information, penalties for breach, and so forth. And again, what happens to this information during and after the term of the agreement? Does it get disposed of? How do you prove it? When does that need to be done? And where will this information be stored? Is it going to be inside or outside of Canada, which has other consequences that I don't want to get into because it will take us down a long road, but it's an important aspect of every contract.
Thank you,
Over to
Esther.
you, Barry.
Thanks, Esther. Now we're getting to the issue of indemnities. Now, indemnities are important because they are a contractual tool that parties can use to allocate liability if something goes wrong in the performance of the contract that results in either a claim between the parties or a claim by a third party not involved in the contract, but in some way suffers monetary or physical damage as a result of what the party's actions. They're often very highly negotiated because generally people and organizations want to avoid liability as much as possible. So what we've often seen in contracts, particularly between charities and not-for-profit businesses or for-profit businesses that are providing service to the charity, is that the business attempts to lay all the risk of loss on the charity by way of an indemnity clause, which is a one-way indemnity in favor of the other contractor. So this is something that you need to carefully consider as a charity. Next slide, please. Because you don't want to unnecessarily expose the charity's assets to risk by way of granting an indemnity to the other contracting party, even if they did something that was their own fault and within their own control. Unfortunately, that is the type of clause we often see in these type of contracts, and we advise clients not to agree to such clauses, because by doing so, you're going to unnecessarily expose your charity to potential claims and legal costs in having to defend not only your own charity, but also the other contracting party. So this is something that you need to carefully think about when you receive a contract from another party in particular, and push back on those clauses that seek to have the charity bear all the risk of loss. Next. Another related type of issue are limitation of liability clauses. We often see these in agreements, especially between charities and for-profit companies that are providing the charities with their standard contracts. The for-profit company seeks to put limits on liability, either a monetary limit or more frequently limits on damages to a certain amount of fees paid. For example, the for-profit business might say no damages can be awarded above 6 months of fees paid prior to the breach of contract. So and there's also clauses that limit or exclude certain type of damages, for instance, punitive damages, loss of profit, loss of goodwill, etc. So, carefully look at these limitation of liability clauses and make sure that you understand what you're signing, because in certain instances, you might not want to have limitations of liability. If the contractor you're dealing with commits some sort of egregious misconduct, you want to be able to go after them for any losses you incur, and you don't want to be limited by a limitation of liability clause. So that's another issue for negotiation between the parties before you sign off on the contract. Next, insurance clauses. Again, insurance clauses are important because you have to know what insurance you as a charity may be required to obtain if you enter into a contract with another party. I've often seen contracts with very onerous insurance clauses on charities. For example, they require the charity to have a certain amount of general liability insurance, errors and omissions insurance, cyber liability insurance, workers' compensation insurance. So if you agree to such clauses, before doing so, you have to talk to your insurance broker and make sure that you actually have that insurance. Because if you don't have the insurance and agree to such a clause, you're automatically going to be in breach of the contract because you don't have the required insurance. So that's another issue of negotiation with a charity and particularly a for-profit business that you're dealing with, and even not-for-profit sometimes. So on the other hand, in certain cases, you may want to require your contracting party to have insurance. I'm going to give a real world example. If a charity is running, for example, a summer camp for children, and the charity wants to contract with a third party company for to provide services in relation to all the aquatic activities taking place at the camp. You want to make sure that the company you're contracting with has all the necessary liability insurance in relation to its activities. So if there is a injury or accident involving one of the campers, that there's going to be insurance to back that up if there's a lawsuit. And in that type of situation, you want to have the charity insured as an additional insured under the other contractor's insurance coverage, because it's not the charity that's providing that service, it's the third party company providing all the aquatic services to the camp. So think carefully about your insurance clauses, as they are important in terms of additional protection to the charity and additional protection also potentially to the directors and officers of the charity, who could also potentially be sued in any type of legal action, especially ones against brought by third parties. Finally, I'm going to get to the so-called boilerplate clauses. We see these typically at the end of the contract. They're not filler. They need to be considered. For example, we often see contracts where if you're contracting with a party in the United States, they want all the legal jurisdiction and clauses to be applicable to apply U.S. law only and not Canadian law. So, and in case of litigation, the contracts say they want to have litigation just in the U.S. jurisdiction, not in Canada. So you don't want to be forced in a situation where you want to litigate in a foreign jurisdiction. If something goes wrong, you want to be able to litigate in Ontario or whatever province your charity is operating in. Finally, the force majeure clauses. Those clauses were rarely thought about until COVID-19 hit, and a lot of organizations were trying to escape contracts because of the COVID-19, and that's when force majeures clauses became more relevant. So think about what issues you want to excuse performance from in the event of some event, a force majeure event. Now, I think these last slides sort of speaks for itself, and I think we'll finish off with the issue of Esther of AI and Google and precedents before we wrap up for today.
Thanks, Barry. So we find often that people think, well, we can just do our own contracts. How hard could it be? And they go online and they get some ideas off, Google, or they use ChatGPT and they come up with something. So this is a very risky approach. It can wind up saving you money in the short term and be highly expensive in the long term for a number of reasons. AI cannot be relied upon. It is clearly deficient in its ability to make judgments. It doesn't have that kind of human capacity, doesn't have the legal judgment. So you could wind up with something that looks like a contract, but it's gibberish, or it's based on, American law, which doesn't apply, or something like that. And it creates major risk exposures for the charity that's trying to use it. You wind up trying to enforce something that makes no sense or that actually puts you at risk. And I've seen a lot of agreements where people cut and paste. So I found this online and I found this, and I'm putting it all together, and they don't know that half of it doesn't reflect the applicable law, or it doesn't make sense, or they're internally inconsistent. And you wind up signing an agreement that has massive problems within it and maybe missing certain key things that you're looking for, like some of the things Barry was talking about. So again, just to reinforce, it is a good idea to get legal advice as early as possible. And it's money well spent, not pumping, we're not here to promote business, but we've seen enough of this. I've worked in this context within a charity, and I would always seek advice where needed, where it was beyond my ability, because it's really, it's a good idea. It's prudent and it makes sense. So I won't bother. Here's some takeaways, but basically the major one is get advice. There's a lot of potential pitfalls. You can wind up risking the assets of your charity, and that can put the board at risk as well as the charity itself. Thanks a lot. Here's our beautiful pictures and our wonderful disclaimer. And we really appreciate you being here today and listening. Thank you.
Well, that's great. Thank you, Esther. Thank you, Barry. You covered a lot of territory and some very helpful handout materials. So thank you for that. Some of the questions that come in have already been answered actually in the in the last couple of slides. So that's helpful. Be very broad and covering a whole bunch of different issues on the contract side for charities and not-for-profits. Here's a question for you, Barry. When should a charity or an NFP require that a contracting party obtain abuse and molestation liability insurance coverage?
Thank you, Terry. Well, whenever a charity is dealing with a situation where they're contracting with a party that has interactions with either minors or vulnerable adults, that is when the issue of abuse and molestation coverage comes up. So it's important to, one, know if your contracting party has such insurance, and two, whether your organization as a charity can be covered under that policy in the event of an unfortunate abuse claim, as these claims can be very expensive, time-consuming, and damaging to an organization if there's no insurance coverage in place as a backstop.
Okay, great. Esther, did you want to comment on that, or is Barry covered that okay?
Yeah, I mean, I concur with what he said. Anyone whose population is vulnerable needs to have this in mind when dealing with contractors.
Okay, great. Yes, over to you, Esther. This individual says we're dealing with a government funder that will not make any changes to the contract. They got all the power, they got all the cards, as they say. Is it still worth having it reviewed?
Yes, absolutely. I mean, for one thing, you need to know what your obligations are under the agreement so you can fulfill them and not breach the contract. And two, you need to understand what the risks are because it may not be something that the organization should do. So you may, again, this is something that the board will have to consider in a case like this, where let's say it's a major funder and you may not survive without the funding. You may make the board may ultimately make the decision to take on a potentially unfair or unbalanced agreement simply because it needs the funding. But it may feel that the funding is not sufficient to offset the potential liability it's taking on. And so may say, no, we're not going to enter into the agreement. So yeah, I mean, you can't just sign on the dotted line just because it's, the government's funding, providing it to you and saying, that's it, that's all.
Okay. Barry, do you have any thoughts on that as well?
Yeah, just as a add on to that answer, if the charity does sign the funding contract and wants to hire any subcontractors to perform any of the services under the funding agreement, the charity needs to make sure that the obligations imposed by the funder flow through to the subcontractor in any subcontracting agreement that is entered into.
Okay, good, thank you. Here's one dealing with IP, intellectual property. So that would deal with the end product of copyright materials or branding associated with trademarks. So the question is, and maybe put it you, Barry, first, and then over to you, Esther. Can you transfer or sell the IP rights to someone else that are tied into the terms of the contract? Barry, any thoughts on that?
Well, it depends on the terms of the contract. If for instance the charity owns the IP created under the contract, it should also have the ability under the contract to deal with the IP as it sees fit. So that would include modifying the IP content and potentially selling it as well.
Okay. Esther, anything you want to add on to that?
Yeah, it also depends on if somebody else has any rights to it. So if the creator retained moral rights or something, you may not have the ability to transfer it. It's all depending on the situation. That there's no one answer I can't think of.
And I think it sort of underscores the importance of drilling deeply into contracts, because these sorts of issues, what can happen, what can you do with rights? It all comes down to the wording of the contract and whether it's anticipated in situations like that. So it's a good reminder to read through and think through with the consequences of contractual terms. Esther, here's a question for you. Should the board of directors have to approve every contract that our organization enters into?
It depends, I guess, on, I mean, as I mentioned earlier, there's two ways to do it. One is the board approves the contract each and every time, which if you're small and nimble, that is fine. Or that there is this sort of corporate policy around this, delegation of authority to management, where management can decide to enter into certain types of agreements up to certain dollar values. So it depends on your comfort level as a board. But either way, the board ultimately is responsible for each decision that is made and holds holding the bag at the end of the day. So it doesn't really matter.
Okay, good. Thanks, Barry. Anything you want to add to that?
No.
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 Okay. So here's a kind of a general one, and put out to both of you. Maybe start with you, Barry. The question is, to what extent do charities and not-for-profits benefit from consumer protection-orientated legislation? Example, warranties, program obsolescence, fees set by utility regulators, etc. So I think I got a little idea on that. But Barry, to what extent do they benefit from consumer protection-orientated legislation?
Well, I have to review my Consumer Protection Acts of Ontario, but I don't think that a charity would be considered
No.
a consumer for most instances under the consumer protection laws that are mainly directed towards individual consumers. But you might have a different thought on that.
Nope, I would tend to agree.
Yeah.
Esther, we got time for one more question. Could you kindly comment generally on donor agreements as contractual agreements? What wording, if any, could charities consider in drafting donor agreements? What happens if, despite having all the terms of the donation laid out in the agreement, a donor advises a charity that they will no longer be able to fulfill the terms of the agreement? Is there anything charities should consider, including in agreements, to ensure the situation is considered appropriately to protect itself, as well as the reputation of the donor? There's a whole bunch of questions all in one. But I think it's instead of dealing with a pledge agreement, I think is
that's
a donor pledge agreement. So some thoughts on that, Esther?
Yes, I mean, in my mind, there's a difference between a donor agreement and a pledge agreement. So when you've been, you made a gift agreement, you've given the gift, and it has certain restricted terms that the charity has to comply with. That's a done deal. The money is over, it belongs to the charity. It has to comply with the restrictions or it's in trouble. So it needs to know what they are. That has to be carefully worded and, agreed upon by both parties. A pledge agreement is an agreement to donate in the future, which may or may not transpire. And yes, there's been some litigation around that, and it's important to make sure that it is carefully drafted. I can't think off the top of my head of particular language that I would want to put in there, but yes, I mean, if you're looking at, doing this on a regular basis, then yes, it's something you should have a carefully drafted template that you utilize with certain key provisions.
Okay. Thanks for that. And just to build on that, we did do a webinar back in February. Actually, I did it on endowment agreements and endowments. So if you're interested in that, you can go to our website. It does have some suggestions concerning what goes into endowment agreements as a type of a restricted gift agreement. And just keep in mind that a pledge agreement is not enforceable. Pledge agreement is an indication of a desire to make a gift, but is not enforceable. Okay, well, we're just about at the end of our time today. Obviously, I want to thank you, Barry and Esther. Really great materials to be able to take away. Just a note to the folks in the audience: the next complimentary webinar in our Winter Spring series is on May the 5th from 12 p.m. to 1 p.m. EDT with Teresa Mann, partner with our firm, presenting on the important topic of T3010 filing time, 10 tips for completing the T3010. And also, please feel free to sign up for our monthly newsletters. You can go to carters.ca for that. Want to thank, of course, Barry and Esther for the presentation today, as well as for our support team here at our firm: Brenda Parsons, Sunil Patel, Jennifer Kirchhoff, Selena Natu, and Mikola Silva. Thank you very much for all of the work that's gone into this. And we just want to wish everyone a great day, and hopefully this has provided you with some tools to use as you move forward. Thanks very much, everyone. Bye-bye.